From the Library of Congress in Washington, D.C.
My topic today is Magna Carta and trial by jury in the New Republic. I'm a legal historian, and I study the legal systems of England, the American colonies, and the United States. That is, rules about civil and criminal procedure, lawyers, juries, and judges. It's a great pleasure to be here with other historians and scholars at the Library of Congress. And in return for this pleasure, I promise not to get into the technical details of pleading trespass on the case or of demurring to the evidence in the 18th century. I became interested in this topic because of bafflement. I was studying the scope of jury trial in the New Republic, and I didn't understand language in a case I was reading. The case was Zylstra versus City of Charleston, and the South Carolina Supreme Court delivered the opinion in 1794. The hapless Zylstra not only had an interesting name, but had been keeping a tallow candle shop in the city of Charleston. This violated a city ordinance because, as the South Carolina Supreme Court helpfully explained, Charleston has a hot climate, and beef tallow, that is beef fat, smells a lot. My husband can attest to this because I make beef bone broth every week, and every week he complains about the smell. Those of you who have adopted a paleo diet, I think, understand this predicament. For violating the ordinance in Charleston, Zylstra was charged in a municipal court which sat without a jury and fined 100 pounds. Zylstra then complained to the Supreme Court of South Carolina that he had a right to jury trial. His counsel argued vigorously that Zylstra was entitled to the inestimable trial by jury, the birthright of every citizen, secured to him by Magna Carta and our excellent Constitution. Wait a minute, I thought. What's Magna Carta got to do with this argument? Is this just the usual overblown rhetoric of lawyers? Well, not entirely, it turned out. The South Carolina Constitution of 1790, like those of most other states in the New Republic, contain the following language: "No freeman of this state shall in any manner be deprived of his life, liberty, or property, but by the judgment of his peers or by the law of the land." Now, we've heard already from both of the two previous speakers the language of Article 29 of Magna Carta. I'm here following the 1225 reissuance, but it's worth hearing again. You might as well hear it a third time. "No freeman shall be taken and imprisoned, or disseised of any free tenement, or of his liberties, or free customs, or outlawed, or exiled, or in any other way destroyed, nor will we go upon him, nor send upon him, except by the lawful judgment of his peers, or by the law of the land." In other words, the majority of states had stuck the language of Article 29 of Magna Carta, translated and with only minor paraphrasing, directly into their constitutions. It thus became, beyond question, the law of the land. But a further surprise awaited me in the Zylstra case. That was the language Judge Thomas Waities used in describing the right to jury trial. He wrote, "The trial by jury is a common law right, not the creature of the Constitution, but originating in time immemorial. It is the inheritance of every individual citizen, the title to which commenced long before the political existence of this society, and which has been held and used inviolate by our ancestors in succession from that period, who knows when that was, to our own time." Well, needless to say, Zylstra got a jury trial. But what is going on here, I wondered? Had Judge Waities lost his mind? He had a constitution in front of him in black and white that was only 4 years old. Why was he talking about time immemorial, the inheritance of every citizen, held and used inviolate by our ancestors. What could he mean? Well, after our first two speakers, now you have a sense of what he meant. But I got the sense when I read that he was referring to a developed strand of thought. I thought I'd better find out about that strand if I wanted to understand ideas about the jury in the New Republic. And thus began my odyssey into Magna Carta, or to be more precise, my odyssey into the fundamental laws of England, of which Magna Carta was the premier example. Where to begin? Ideas about Magna Carta and jury trial have changed quite a bit in 800 years. A logical place to begin is at the beginning in 1215. As it turns out, the barons at Runnymede could not possibly have intended to guarantee common law trial by jury. Jury trial did not exist for criminal cases in 1215, and only for certain types of civil cases. In Article 29, the phrase judgment of his peers per judicium parium meant that no one could be tried by his inferiors. The barons, therefore, thought that they should be tried by each other, a concept that survived in the trial of peers in the House of Lords. The barons did not consider royal judges to be their peers, much less the common folk that made up ordinary juries. In the 14th century, new understandings of Article 29 arose that encouraged a future link to common law trial by jury. The 14th century was again a time of great conflict between the crown and the nobility. Parliament enacted a series of statutes that were later much celebrated that referred to Magna Carta and confirmed that a trial following lawful procedures should take place before judgment. Several of these 14th century statutes used a phrase we've heard about from both of our previous two speakers, due process of law, which thus became deeply associated with Magna Carta. The words due process of law do not occur in Magna Carta, they come from those 14th century statutes. Beginning in the Tudor period, and especially in the 17th century, English writers explicitly linked the phrase judgment of his peers in Magna Carta to common law jury trial. They described this right as an ancient inheritance. The first person to make this link in print appears to have been William Lambarde in his Aranarca of 1581. Lambarde, importantly, was an antiquarian, a collector of Anglo-Saxon laws. He was one of a number of antiquarians interested in tracing the ancient constitution of England, in many cases back to the Anglo-Saxons. Lambarde's Aranarca was familiar to Americans and was found in the libraries of Thomas Jefferson and George Wythe, among others. During the constitutional struggles of the 17th century, Edward Coke, a name we've heard about from both of our previous two speakers, was happy to embellish this theme of linking Magna Carta and jury trial. This link aided Coke's quest, in his later career at least, to strengthen the common law courts and to limit chancery and the other prerogative courts. The prerogative courts sat without juries and were more directly subject to royal control. Coke extensively discussed Article 29 of Magna Carta in his Second Institutes, a source well known to Americans, as we've heard. Coke was the most influential exponent of the idea of an English inheritance based on descent and consisting of fundamental laws. In Coke's view, this inheritance was unchanging and from time immemorial. It preceded the Norman conquest and endured to Coke's day. According to the fundamental laws expressed in Magna Carta and other sources, the king could not take property from his subjects or imprison them without due process of law. The law of the land specified what process was due, and its most important component was the common law of England. So we can now start to see the origin of Judge Wady's ideas in South Carolina in the 1790s. A difficulty was that the English in England and the English in America held different views about the extent to which the fundamental laws, including the common law, applied outside of England. Coke himself did not believe that the full panoply of these rights applied outside of England. Blackstone certainly did not. He wrote in his commentaries that Parliament had plenary control over the overseas colonies because these lands were conquered. The English in America, in contrast, insisted that their lands were settled, not conquered. The existing populations had died in large numbers because of Old World diseases, and the remainders had fled or were assimilated, eventually. Colonial charters, furthermore, purported to give, as we've heard, English settlers in the colonies and their descendants the full rights of Englishmen, as if they had been abiding and born within this our realm of England. The American insistence on their rights as Englishmen is something that it's important for us to understand. It's often overlooked in contemporary education. But, unlike many things that are overlooked in contemporary education, it's been overlooked for some time because of the desire to assimilate immigrants from other countries and because of the forging of an independent American identity. The theory we proclaim today is that the United States is a nation founded on universal principles, not on blood. Many American colonists and revolutionaries had a different view. They thought of their rights as an ancient inheritance based on their blood. They conflated, in some cases, their rights as Englishmen with the universal rights as man. At every opportunity in proclaiming their liberties, they harped on their ancestors and their descendants. You see these words over and over again in statements of American liberty: fathers, children, posterity, and so on. For the most part, they did not mean spiritual ancestors or descendants. They meant flesh and blood. The transformation from a blood descent to spiritual descent came later. Abraham Lincoln expressed that transformation most eloquently in a speech he gave to commemorate Independence Day in Chicago in 1858, drawing on the words of the Declaration of Independence. Back in the 18th century, like Edward Cook, many American colonists believed that their inheritance was unchanging and from ancient times, from time immemorial. No king or parliament could rightfully alter this birthright of the English people. The body of this inheritance was, as Cook had explained, the fundamental laws of England, especially as expressed in Magna Carta. And as we've heard already this morning, to an astonishing extent, the American colonists printed, distributed, invoked, and formally enacted passages from Magna Carta. Thomas Jefferson's views about the immemorial English Constitution were widespread among educated colonists and helped to explain American devotion to Magna Carta. Jefferson, for all his declaration of the universal rights of man in the Declaration of Independence, had imbibed early and promoted energetically the Whig idea that the ancient English Constitution and common law were legacies of the Anglo-Saxons. Central to this ancient English Constitution and common law was a primitive democracy, supposedly embodied in such free institutions as the folk moot and trial by jury. Never mind that the Normans, in fact, introduced trial by jury. Jefferson was so enamored of the Anglo-Saxons that in 1776 he proposed an official seal for the United States showing the figures of Hengist and Horsa. Who are those characters, you might wonder? Okay, we're working. There they are. These were two German chiefs, possibly legendary, who were allegedly brothers and among the first Anglo-Saxon invaders of Britain in the 5th century. Hengist means stallion in Anglo-Saxon, and Horsa means horse. So this was a family evidently with an equine obsession. You see in the bottom right there of the picture a horse banner. Individually, these good common free Germans carrying the horse banner there. And interestingly, to show you the link with the mythical past, you see horse-headed gables like this on farmhouses throughout northern Germany, the Netherlands, and Scandinavia. In other words, the places where the Anglo-Saxons were from. These gables appear to reflect an ancient Indo-European myth about divine twins, probably originally horse-shaped. And through the late 19th century in Germany, these gables were known as Hengist and Horse. So we are deep into ancestral mythology here. Jefferson described Hengist and Horsa as the Saxon chiefs from whom we claim the honor of being descended and whose political principles and form of government we have assumed. In the Whig Story championed by Jefferson, the depraved Normans were the evildoers. The French-speaking Normans imposed feudalism and temporarily deformed the rights of Englishmen. Magna Carta, fortunately, restored these ancient rights. The constitutional battles of the 17th century were further examples of the English asserting their rights against tyrants. Americans saw themselves in a continuation of this struggle to preserve the ancient rights of Englishmen against usurpers. As tensions built between the North Atlantic colonies and Britain, American invocations of Magna Carta became more aggressive. This is a $4 bill printed in Maryland in 1775. My children were very interested in the idea of a $4 bill. They wanted one. Not sure it would still be legal tender today. We'll take a closer look at it. I hope. There we go. This woodcut shows the figure of Liberty on the right there. She's holding a pole with a cap on it, her typical symbolism, and she is standing on the word slavery underneath her there. And she's backed by American troops carrying the banner of liberty. You might be able to see the LIB on there. The figure of liberty is handing a petition to Britannia in the middle with a shield and spear. Britannia, though, unfortunately, is restrained by King George III, the large figure on the left, who is shown trampling Magna Carta. So in the base that he's standing on, it says M. Carta, standing for Magna Carta. And for good measure, King George is setting fire to the port of Annapolis. Many Americans claimed, therefore, that they had an inheritance and they were not giving it up without a fight. For Americans, the jury was not only part of their ancient inheritance as Englishmen, protected by Magna Carta, or so they thought, but the jury had proved very useful during the colonial period in the conflict with the British government. And we've heard about this from Professor Malcolm already. At the heart of the American fervor about the jury was the institution's ability to nullify unpopular laws. On the criminal side, one of the most prominent examples was the acquittal of the printer John Peter Zenger in 1736 in his trial for seditious libel of the colonial governor of New York. American juries either refused to indict or acquitted so often in cases of seditious libel that the law became essentially a dead letter in the colonies, in contrast to England, where there were a number of successful prosecutions for seditious libel. Civil juries were prized for their ability to nullify the customs laws by awarding plaintiffs damages in trespass cases against customs tax collectors. And I'm surprised John Hancock didn't think of that. But maybe he tried, it didn't work out for some reason. This practice exasperated British officials. The royal governor of Massachusetts, Francis Bernard, complained in 1761 that a custom house officer has no chance with the jury, let his cause be what it will. Bernard warned his superiors in London that these verdicts effectively overturned the judgments of the courts of admiralty, which sat without juries. Another colonial governor of Massachusetts wrote that a trial by jury here is only trying one illicit traitor by his fellows, or at least by his well-wishers. Colonists viewed the jurisdiction of the juryless admiralty courts as a major grievance. They repeatedly complained about the curtailment of the right to jury trial, and in particular, in the Stamp Act Congress of 1765 and the Declaration of Independence a decade later. The British government, in the view of many Americans, was depriving them of their birthright to trial by jury in Magna Carta, and thus preventing them from nullifying the hated customs laws. And this view accounts for the immediate insertion of the language of Article 29 of Magna Carta into these new state constitutions. Again, it took place as early as that. As soon as the state constitutions were written, the majority of them put that language right into them. Here was the difficulty. Once the Republican governments took power, however, jury nullification became deeply problematic. The people now had a say in the making of laws. They had consented to them. Why should 12 citizens have the power to nullify laws enacted by a legislature elected by the entire people? Furthermore, legislatures followed a process for enacting laws carefully specified in a written constitution, itself ratified by the people. At the time the federal constitution was drafted in 1787, the Federalists began to express publicly doubts about the civil jury. Anti-Federalists, such as Patrick Henry of Virginia, argued strenuously in favor of it. The specific issue that Henry called attention to was the civil jury's ability to nullify debts. Debtors were a powerful political force soon after the Revolution. State legislatures passed laws that made it easier for debtors to escape creditors' demands. In addition, state juries were sympathetic to debtors. These creditors were often British merchants, not a particularly popular group in America at the time. Anti-Federalists protested the lack of a civil jury right in the federal constitution. They were afraid that debtors would be hauled into federal court and made to pay their debts. The Anti-Federalists succeeded in persuading a reluctant James Madison to draft a federal Bill of Rights, including a right to civil jury trial in the Seventh Amendment. In drafting what became the Seventh Amendment, Madison studiously avoided glorifying the civil jury. He had argued against the need for a civil jury right in the Virginia Ratifying Convention, directly opposing Patrick Henry. Madison therefore decided to make no direct reference to Magna Carta in the Seventh Amendment. The Federalists' concerns about the jury presaged the attitudes of many later legislators and judges in the United States. Politicians and judges continued and continue to praise the jury in extravagant terms and to exalt Magna Carta as the guarantee of this liberty. Year by year, however, they whittled the jury away. This erosion was especially true of the civil jury. At the founding, the jury had been a political institution, as Tocqueville famously described it. In the 19th century, however, many Americans in all areas wanted predictable, uniform legal rules that would help to promote commercial development. Use of civil juries could lead to unlawful, unpredictable results that undermined the authority of legislatures and courts and thwarted the ability to plan and carry out actions. Besides, the expense and inconvenience of jury trial was great. And one of the most surprising things about reading state constitutional conventions in the early 19th century was how often delegates complained about the jurors having to spend their time listening to their neighbors' complaints. The jury began to be regarded more as a judicial institution than as a political one. And as a judicial institution, the jury fell short. We see the shift in attitudes toward the jury in the opinions of state and federal courts. As we saw previously, the South Carolina Supreme Court in 1794, in the Zylstra case, lauded Magna Carta and required a jury trial. As the Republic matured, however, courts dropped the language of ancestors and rights from time immemorial and focused on efficiency at adjudication. The 1819 opinion of the U.S. Supreme Court in Bank of Columbia versus Oakley is a good example of the new emphasis on efficiency. That case concerned a summary proceeding by a bank against a debtor. The debtor complained that he was being deprived of his right to jury trial under the Maryland Constitution. The Maryland Constitution was one of those that directly incorporated the language of Magna Carta, Article 29. Justice William Johnson wrote the opinion, and as it happened, he was a native of Charleston. He took a different attitude toward the Magna Carta than had his fellow South Carolinian Thomas Waites. In his opinion for the court, Justice Johnson wasted no time with the usual fulsome praise of the language of the Great Charter. His tone indeed suggested impatience with what he called the volumes spoken and written with a view to their exposition. Instead of trying to carefully interpret the words in light of respected scholarly authorities, as Judge Waites had done, Justice Johnson peremptorily declared that the good sense of mankind had at last arrived at the idea that they were intended to secure the individual from the arbitrary exercise of the powers of government, unrestrained by the established principles of private rights and distributive justice. After this announcement, Justice Johnson explained that the debtor had chosen to make his note negotiable at the bank, and therefore he had waived the right to jury trial. By the mid-19th century in both England and America, the powers of the civil jury were increasingly curtailed. The jury went from being described as a sacred palladium, as Blackstone had called it, to a figure of fun. The English humor magazine Punch got in on the act. They seldom missed the opportunity. And they published a book called The Comic Blackstone by Gilbert A. Beckett in 1846. The most quoted passage, and one singled out for admiration in the United States, was a satire on Blackstone's chapter on the civil jury. Beckett referred to the ancient inheritance of Englishmen. The trial by jury is, of course, a subject that every true-born Briton with a quarter of a pint of Saxon blood in his veins is prepared to revel in. Beckett went on to observe that jurors were often befuddled by the arguments of counsel, and that they sometimes flipped a coin to decide cases. The story of the jury moving from an ancient and prized right of the people to a nuisance suggests the difficulties of constitutionalizing specific procedural rights. Legal systems, economies, and politics can change, changing in turn the need or the desire for a particular procedure. The idea of the jury as a right of Englishmen from time immemorial was a fiction, a myth. The criminal jury was unknown in 1215, and the barons at Runnymede insisted that the common law jury did not apply to them in the most important civil cases. The notion of the jury as an ancient right suited Coke in his struggles against royal prerogative in the 17th century, and it suited Americans in their struggles against British control in the 18th century. After these battles were over, the civil jury seemed to many to be a liability. The legal system needed new procedures that were more efficient for commercial societies. The more enduring legacy of Magna Carta is the one that Justice William Johnson pointed to in Bank of Columbia versus Oakley, the idea that the individual should be secure from the arbitrary exercise of the powers of government. Thank you.
This has been a presentation of the Library of Congress. Visit us at loc.gov.